Hello, everyone, and welcome to today's webinar organized by Maya Brown in cooperation with the Legal 500 and Thomson Reuters, the new legal frameworks for vertical agreements in the EU and UK. My name is Margherita Birri. I am an editor at the Legal 500, and today we are delighted to be partnering with Thomson Reuters and Maya Brown. Just to give you an overview of the topic, since now, just a week ago, on the 1st of June 2022, the new legal frameworks for the assessment of vertical agreements have entered into force in the EU and in the UK. In this webinar, Sarvena Schiani from Maya Brown and Varsha Calais from Thomson Reuters will moderate a discussion with Johannes Olsbach from the European Commission and Ricardo Araujo from the UK Competition and Markets Authority on the practical implications of the main legal changes arising from the new EU and UK vertical frameworks, as well as the areas where the regimes might diverge. A big thank you to both the guest panelists for joining us today. So we have Johannes Olsbach, who's a case handler officer at the DG Competitions Unit A1, Antitrust Case Support and Policy. In this position, he provides procedural and substantive support to case teams and develops policy and law in the field of antitrust. Johannes is part of the team that worked on the revision of the vertical block exemption regulation and the vertical guidelines, and is therefore a very versed expert in the topic. Ricardo Araujo is an assistant legal director at the UK Competition and Markets Authority Legal Service. His role includes providing legal advice to case teams investigating potential antitrust breaches, as well as providing legal input into policy projects. More recently, he had a leading role on the review of the UK retained vertical agreements block exemption regulation, including on the development of the CMA guidance on the vertical agreements block exemption order 2022. So like Johannes, we are very happy to have Ricardo's expert knowledge on our panel today. Further, I would like to introduce our moderators. Sarvena Schiani, who's counsel at Maya Brown, working in the Düsseldorf and London offices, who has in-depth experience in the area of vertical agreements, having worked on landmark cases, and who is advising clients frequently on these questions under EU and UK law. And Varsha Calais, senior legal editor at Thomson Reuters, with more than 20 years experience in competition law, working previously in private practice. So we would like the discussion to be as interactive as possible, so we welcome the audience's questions through our Q&A function. We will have time at the end of the session to answer your questions, and we will try to follow up after the session in case questions remain unanswered. As you will see, the panelists are in Maya Brown Brussels offices today. Unfortunately, Varsha could not join in person, but will be contributing remotely. The webinar will be recorded, and the recording will be made accessible to the registered audience. I now hand it over to Varsha and Sarvena. Thank you.
Thank you very much, Margherita. Thanks to Legal 500. And may I also, on behalf of Thomson Reuters, welcome our distinguished guest today. I'm really sorry I can't be there in person. Today I have COVID, so I'm pretty sure our distinguished panel will be quite happy to keep me at a distance. Before we dive into the detail, I just wanted to spend a few moments setting the scene. And I wanted really to explain why these new rules governing vertical agreements and their respective accompanying guidance and guidelines are commercially so important for business. We're talking today about vertical agreements, that is, agreements between parties at different levels of the supply chain, for example, distribution or supply agreements. And these are really bread and butter commercial agreements for business. Parties to such agreements often wish to include vertical restraints in those agreements to deal with a specific economic issue. For example, to ensure that distributors make sufficient investments in sales promotions, even when there is a free riding risk. But as such vertical agreements are between separate economic entities, they are subject to the competition rules, and in particular, the general prohibition against restrictive agreements and arrangements, as set out in Article 101 of the Treaty on Functioning of the European Union, and also Chapter 1 of the Competition Act in the UK. But given the potential efficiencies which are involved, vertical agreements can also satisfy the conditions for legal exemption under 101 and Chapter 1. This is possible when the restrictive effects associated with any vertical restraints are in fact outweighed by consumer benefits. However, the onus in all cases is on the parties to the agreement to self-assess whether their agreement, including all restraints contained within, is compatible with competition law. It is for the parties to satisfy themselves that there is no infringement. In practice, this can be quite tricky to assess whether agreements are in fact exempt, given that even if there are good efficiency justifications, given that such exemptions should always be construed narrowly. This is where the commercial importance of the block exemption comes in. It provides a safe harbor for categories of agreement considered sufficiently certain by the authority to satisfy the criteria for exemption in terms of conferring sufficient benefits to outweigh any potentially anti-competitive effects. In this sense, the block exemption can be seen as providing a legal shortcut for parties, assuming the block exemption thresholds are satisfied in terms of the market share thresholds and that there are no hardcore restrictions contained within the agreement. Parties should have the confidence to enter into agreements without the risk of these agreements being declared unenforceable, and this should in turn reduce compliance costs for business. Moreover, even when an agreement falls outside the block exemption and the parties need to do an individual assessment of that agreement, the accompanying detailed guidelines to the legislation are of really paramount importance. I don't think their importance can be overstressed. They provide invaluable technical guidance to business when assessing whether any particular agreements are exempted and therefore enforceable, again, reducing compliance costs. Finally, by putting the onus on the parties to self-assess, this really should free up resources from the authorities' side to focus on more serious infringements. And in that sense, you could see it as perhaps a win-win situation for both business and competition authorities. So now turning to the current rules, which came into force last week on the 1st of June in both the UK and the EU, I think the first point to make is that these represent really a major revision from the last set of rules, which date from 2010, which is actually, in fact, 12 years ago. This new set of rules is the culmination of a very detailed revision and consultation process, particularly at EU level, which resulted in quite significant changes to both the technical guidance as well as the legislation. These new rules squarely address the new challenges posed by e-commerce and the internet. And for the UK in particular, I think this actually represented the first major opportunity for the UK to diverge from retained EU law post-Brexit, as it's the first and probably the most important block exemption to expire post-Brexit. However, although the UK guidance is not yet final, I think it's fair to say that the two sets of rules are generally aligned, which will be, I think, of great reassurance to business. Today, we will, however, be talking about some of the areas where the EU and the UK frameworks do diverge or seem to diverge, and what this means for business, and whether actually any perceived differences really matter in practice. Finally, although there is a 12-month transition period under both sets of rules for businesses to give them sufficient time to comply, to achieve compliance, I think it's worth noting as well that while the waiver will be enforced for 12 years, the UK Purveyor will actually expire in 6 years' time. And that is perhaps something our speakers may wish to comment about in due course. But that's enough from me. Without further ado, I'd like to hand over to Sarvanas to discuss some of the detail in the vertical frameworks. Thank you very much.
Thank you, Warsha, for this very helpful background to set the scene for today's webinar and also for the deep dive into the topics. So we have chosen a few topics we would like to discuss in detail today, where we think that the changes are maybe the most important and may have the most practical implications. So we are going to discuss dual distribution and information exchange, online platforms, selective distribution, and in particular online restrictions. We are going to briefly touch upon exclusive distribution systems and then finish on parity clauses. So quite a lot of topics. But before we start with this deep dive, I wanted to give both the speakers, Johannes and Ricardo, and thank you, by the way, for joining the panel, for crossing the channel, for crossing the street to join us at Maya Brown's offices today. I wanted to give you the floor first to ask you a quite broad question. What are the main or the three main achievements that you think will be brought in by the revisions? Maybe Johannes, you want to kick off.
Sure. Yeah, thank you very much for having me here. And I have to start with the disclaimer. So what I say is my personal view on this. It's not necessarily the Commission's view. And with that, I would like to say that the main achievement is bringing this over the finishing line. And more, on a more serious note, I think the achievements with the new rules and the guidance relate to the objectives of this entire review of the vertical block exception regulation. So there was this objective of addressing false positives and false negatives, and we'll touch upon all of these in our discussion today, I'm very sure. So I think that's one of the main achievements to address these, having addressed these false positives and false negatives. And there's also this area of updates, and it's actually a big area. So it's online sales restrictions, platforms under the VBER. I think it's a main achievement of the new rules to address online sales restrictions and online advertising restrictions in a manner that takes into account the growth of e-commerce and the emergence of platforms. And platforms is also another area related to these updates, and the main achievement is really to cover platforms in the new rules and address them in the new guidance in a way that tries to take into account the specificities of platforms. And the third objective was to simplify this. I mean, the guidelines are much longer now than the old guidelines, but I think there are some key aspects that have been simplified, including the introduction, setting out the economics that really underlie the entire rules. So I think the three objectives of the VBER review have been met, and these are the three main achievements of the VBER review.
I can assure that we will come back to most of the points and check on the achievements in the course of the webinar. So looking at you, Ricardo, and at the UK, of course, there are some similarities between the new UK system and the new EU system. From your perspective, what would you say are the main achievements?
First of all, thank you very much for the invitation. Absolutely delighted to take part in today's discussion. Such an important time for the vertical regime, both in the UK and in the EU. And I'd also like to start by making a similar disclaimer. The views expressed today are my very own personal views, should not be interpreted as the CMA's views on any of the matters under discussion. Just picking up on a point that was made, and before I actually address the question of the three major achievements, it was mentioned that the CMA and UK's position and guidance on verticals is broadly consistent with the Commission's approach on the various issues. And so I'd like to start off by acknowledging that point. And the CMA was very much aware that the previous verticals guidance was in place in the UK for a very substantial period of time, for 12 years. And I was mindful of the fact that any radical departure from the current regime could have the unintended consequence of creating some legal uncertainty for some businesses, notably the ones that operate cross-border. And as it was already mentioned, we nonetheless did see material advantages in terms of diverging from the position at EU level in some specific areas where we felt there was, from a UK perspective, an opportunity to tackle what we perceived a risk for potential anti-competitive behavior harming UK consumers. But I'm sure we'll go back to that point. In terms of addressing your original question, I think having a block exemption is an achievement in and of itself, given the benefits that stem from it, notably in the enhancement of legal certainty, reducing compliance costs for business, And first and foremost, having a common framework which business can use in order to assess their vertical agreements. So this is a very important achievement, and this is why we recommended to the UK government that the retained block exemption should be replaced by a new UK block exemption order. More specifically, in terms of what we perceive as achievements, and Johannes already touched upon this point, the new rules and accompanying guidance do reflect significant market developments that occurred over the past 12 years, notably the growth of online sales. And so one of the achievements of the new regime is really to provide legal certainty in relation to novel issues, and it does have the merit of clarifying the distinction between active and passive sales in the online world, and also to clarify the position in terms of dual pricing, equivalence, and the position of online intermediation services. So this was an update which was overdue, and certainly one that we see as a major achievement. Secondly, we think it's important to recognize that the new regime does provide more flexibility for businesses to design the distribution systems according to their needs, and this is translated in terms of enabling businesses to adopt shared exclusivity arrangements and to combine different types of distribution models in the same or in different territories, as well as providing greater protection for members of selective distribution systems. And we're very much aware that this was an aspiration of many stakeholders now for quite some time, and we hope that we have delivered on that. And finally, as it was already mentioned, this is the first post-Brexit block exemption order in the UK, and we're very happy with the fact that in our view the new UK regime does strike a reasonable balance in terms of ensuring, on the one hand, consistency with the previous regime, whilst grasping some of the opportunities which I already mentioned to diverge in some areas. Or we think that from a UK perspective, there were specifics in the market justifying a slightly different approach in the UK.
And we will definitely discuss those points where you took a different approach, as it is very important, of course, for clients that have distribution systems, not only in Europe, but also in the UK. So let's go to the first of our topics that we wanted to discuss in a bit of detail. I know, Johannes, you know this topic inside out. It's about dual distribution, and in particular, information exchange in the context of dual distribution. So what is dual distribution? Because Warsha just explained to us that actually the vertical agreement frameworks is in relation to agreements between two players on different level of the supply chain. So dual distribution brings a nuance to that, because this refers to scenarios where the supplier not only sells products to resellers, but also sells the products directly to end consumers. For instance, we are their D2C, their direct to consumer branch, their e-commerce branch, and there has certainly been push into D2C systems due to the pandemic. Under the old regime, there wasn't much specifically about dual distribution in the legal framework. It was clear that there is this element of horizontal relationship between the supplier and the reseller, who then do also compete on the retail level. And from a private practice perspective, the task really was to advise on how to tackle this horizontal element, which was also ancillary to the vertical agreement. Now, under the new frameworks, under the guidelines, the draft guidance, there's actually quite a lot of helpful clarification with regards to how to deal with dual distribution, and in particular, how to deal with information exchange as part of a dual distribution scenario. Johannes, would you like to explain to us what are the main changes, and whether in practice they really will change so much compared to the old system. But maybe at first, what are the main changes when we look at dual distribution and information exchange under the new framework?
Yeah, of course. So when it comes to dual distribution, one has to consider that on the one hand, the scope for dual distribution was a little bit broadened because it now also covers other participants or other companies active in the supply chain, importers and wholesalers. But at the same time, the dual distribution exception, so the limitation to the safe harbor, is put in place with regard to information exchange. And you've mentioned it before, Sabinas. The focus at the beginning of this review was on dual distribution as such, whether it's really warranted to continue block exempting dual distribution, or whether the whole system of dual distribution when it comes to the safe harbor should be limited. And the review process has focused then a lot on information exchange, because that ultimately came also from stakeholders confirming that when it comes to information exchange, the block exemption regulation, the old one, block exempted certain practices that did not generally fulfill the conditions of Article 1013. And Washa explained it at the beginning. That's basically the test for us. So the new rules focus on information exchange, and they maintain the block exemption regulation for information exchange that is directly related to the implementation of the vertical agreement and necessary for the production or distribution of the contract goods or services. So it's a two-legged test. It goes back to what was proposed in a draft that was subject to a public consultation, a short one at the beginning of this year, and it really strikes the balance of covering the situation of information exchange in dual distribution and acknowledging, you have to read this together with the recitals of the vertical block exemption regulation, because the starting point is that information exchange in dual distribution is also efficiency enhancing. That's the starting point, because there is a vertical element, but there's also this horizontal element that may not justify block exempting dual distribution as such across the board when it comes to information exchange. And the test in the regulation has to be read not only with the recitals, but also with the guidelines. And in the guidelines, you have examples of when the test is fulfilled and when the test is most likely not fulfilled. And these are examples, but nevertheless, they're there to provide guidance to companies and stakeholders that have to apply the rules.
Yeah. So by way of summary, dual distribution is continues to be block exempted. When it comes to information exchange, parties have to look at the agreement and they have to look at the information they plan to exchange. So the supplier in the buyer, the supplier normally asks the buyer for information. Sometimes the buyer may also ask for information from the supplier. And here, if I understand the new rules correctly, one has to conduct an assessment for each agreement, whether the information is directly related to the implementation of the agreement and necessary for the implementation of the agreement.
That's correct. That's the two-legged test. But I think the starting point, and I would consider this even a presumption that information exchange also in dual distribution is normally efficiency enhancing, and therefore the test will be fulfilled. But again, it's for the companies to self-assess, and the guidelines provide some examples that address some typical situations of information exchange.
And what now if, in the rather unlikely case, as you say, because you say mostly it should be efficiency enhancing, companies come to the result that it may not be block exempt, it may not be fully necessary or required for the implementation. Does this mean that then that kind of information exchange is fully illegal and not possible?
Yes, I mean, it's a very good point, because it's also addressed in the guidelines. And when it's not covered by the test, so you come to the conclusion the test is not fulfilled, then it's an individual assessment. And this is just how a normal, also a block exemption regulation works. If it's not covered by the block exemption regulation, we're back to an individual assessment. And because dual distribution has these two elements, horizontal and vertical, The horizontal aspects should be analyzed also by reference to the horizontal guidelines, and the vertical aspects should be analyzed under the guidance that is provided in the vertical guidelines. There's a whole section on what happens if an agreement falls outside the scope of the vertical block exemption regulation. It's a long section at the end of the guidelines, and there are some principles, and those principles should be applied.
Okay, but it doesn't mean that because information is maybe illegal that the entire agreement can't be block exempted anymore.
That's also clarified in the guidelines. There is this paragraph that deals with the legal consequences, and indeed that's the case. So the vertical agreement as such can still benefit from the block exemption regulation, but it's really the information exchange that raises these horizontal concerns and should be subject to a self-assessment.
So turning to the UK, Ricardo, unlike under the EU regime, where we have some explicit wording on dual distribution and information exchange in the VBAR itself, in the UK, I think it's mostly handled within the draft guidance. I would say the test is similar, but it's not identical. So maybe you want to help us. What is the difference, if any, and how is the assessment under the UK regime?
You are right that in that there are some differences, in particular in terms of the wording used in the final version of the Commission's guidelines and the CMA's draft guidance. But I think the position, the substantive position, is broadly similar. So to clarify, the UK position is that if the conditions for the dual distribution exemption, which are set out in detail in the block exemption order itself, if those conditions are met, then the benefit of the block exemption applies, including to the information exchanges that take place under the dual distribution arrangement. That said, there are a few caveats, which I think, even though the wording used is slightly different, they pretty much amount to the two limbs that the Commission has set out in the test in its guidance. So the exemption of the block exemption does not extend to horizontal restrictions of competition by object, and we make that point very clearly in the guidance. The block exemption only covers restraints which are genuinely vertical. It does not extend to horizontal agreements between competing undertakings. Even in instances where those exchanges of information may take place under a vertical arrangement, what matters is the substance of those information exchanges rather than the form. So I think in that sense, we pretty much have a similar position to the one adopted by the Commission. Now, I guess the crucial question is really to understand whether a specific exchange of information is genuinely vertical, or in other words, whether it's required to implement the vertical agreement. And I personally think that businesses are particularly well placed to carry out that assessment, which should be carried out on a case-by-case basis. Even though we do provide some pointers in the guidance itself in terms of listing types of information exchange which we think are block exempted, are likely to meet the conditions for individual exemption, and other ones which clearly fall outside the mark. So we fully appreciate that there will inevitably be some borderline cases which will be very, very difficult to assess. But for those cases, we do think that self-assessment by businesses is the way to go, bearing in mind the principles that we set out in the guidance. And then the other part of your question, which is, so what happens when the information exchange is not covered or does not benefit from the block exemption? Again, I think that our position in the UK is similar to the position at EU level, in that in those instances, the information exchange must be assessed individually against the Chapter 1 prohibition in the UK Competition Act, and you know, potentially in those cases you'll have to have regard to the horizontal guidelines which refer to exchange of information between competitors. So I think that's the next step for situations where the info exchange is not block exempted. And in addition to that, in those instances, businesses may wish to consider introducing additional risk mitigating measures, such as firewalls, for example, information barriers. And I think that these two things coupled together would provide sufficient legal certainty.
Yeah, the question about firewalls very often is a question we deal with. But now I think with the new guidance and the clarifications that we received, I think companies understand also better the use of such firewalls, and it's rather an add-on once one has assessed whether the information is necessary and required, and then only in a gray area maybe a firewall could help. But we know it's said in the guidelines, firewalls cannot help to bring a context back under the block exemption if it's actually not block exempted. So I think we should move to our next topic, because you are both already mentioned it in your achievements, and I think it's also an area which is quite new. The legal assessment will be quite new, and it's also quite complex. So it relates to platforms, online platforms. Both frameworks introduce a definition for online intermediation services, in simple language, online platforms, and new rules how dealings agreements with online intermediation services have to be assessed under the WIBOR or outside the WIBOR under the general competition law rules. And my impression so far is that the changes may lead to some nervousness in the market among stakeholders, because there's maybe not as much clarity as there was before how to assess agreements. But maybe we take it step by step. Johannes, so what are the new rules? How does the new definition of online intermediation services fit under the WIBOR, and what did the Commission want to target with this new rules?
Yeah, so I mentioned it as one of the main achievements, and I think it is, and it's not necessarily, in my view, it's not such a great change, because the vertical block exemption regulation, the old one, already applied to vertical agreements entered into by platforms before the adoption of the new WIBOR. It's just that the new rules try to address platforms more specifically by reference to a definition that is also used in other EU legislation. The platform to business regulation and also in the DMA, they all draw upon this notion of online intermediation services. And the new definition in the vertical block exemption regulation takes inspiration from those definitions, and it tries to square platforms within the concept, the legal framework of the vertical block exemption regulation. And it's quite difficult because platforms have different business models. Sometimes they act as normal resellers. Then the question about how the WIBOR, the regulation applies, does not even arise. But in other instances, it's not so clear. And in particular, when it comes to intermediation services, the legal uncertainty that might have existed previously is addressed by this definition. And the definition says that when an undertaking provides online intermediation services, it's considered a supplier under the vertical block exemption regulation. And that has some legal consequences. You know all of these consequences, but they're also spelled out in the guidelines. And that is meant to provide more legal certainty. Now, this definition is very targeted, and it's not meant to cover all types of situations of platforms, because platforms are so diverse. And I think this you have to take into account, you have to keep this in mind. And when an undertaking, so the bottom line is, when an undertaking meets the definition of an online intermediation services provider under the WIBOR, it's treated as a supplier. If an undertaking does not meet this definition, Then we're back to the self-assessment principle that also applied under the old Weber. Platforms have to then self-assess whether they're suppliers or buyers under the Weber, and the guidelines provide some guidance on this. But again, this is such a broad topic. I'm sure there are constellations that are particularly difficult to solve.
That was very helpful. So when you say a platform has to assess whether they meet the definition of online intermediation services, is my understanding correct that you mean a platform needs in every specific situation assess? For instance, if a platform only acts as a reseller, is this what you mean with one needs to assess whether they meet the definition?
Yes, I mean, the definition, the core element of the definition is facilitating a direct transaction between two other parties. So it's just this facilitation of another agreement. And then the intermediation service, the platform service, is just an input to another transaction. And I think this is what one has to understand. And it's, I mean, of course, there are in practice, you have business models where the service of online intermediation is combined with other services. And there's also some guidance in the guidelines on this, because the new definition builds upon existing definitions in the P2B and then also on information service societies. There is already case law on this, but the idea of having one definition that is more or less aligned across the board of all EU legislation, I think makes it also easier for platforms to self-assess, knowing that if I meet this definition, these are the rules that apply to my business model. And yes, you have to look at each vertical agreement individually. Now, some platforms might have standard agreements, and so therefore this might be in practice a shortcut for them. But from a Weber perspective, the vertical block exemption regulation exempts vertical agreements, and therefore you have to identify what is the vertical agreement, and to apply the Weber, you also have to identify who's the supplier, who's the buyer, and that is a self-assessment that you will still have to do as a platform if you don't meet this definition, which is a shortcut to telling a platform that in this specific circumstances, you're a supplier.
So if a buyer of the online intermediation services then thinks about how am I now going to sell my goods via the platform, the freedom of taking decisions as the reseller on the platform is not impacted by the fact that the online intermediation service is the supplier of services. This is now a little bit complex. What I really want to get at is that nowadays, many buyers of online intermediation services have their agreement structured as agency, genuine agency, which may or may not fully be accurate. So now they are need to check their agreements and think, how am I going to continue my relationship with this platform? I want the online intermediation services, but I want to be in full control of how my products are being sold over the platform. And from what you've just said and what I understood, I think that will not change in future, because that is a separate dealing, how the seller is determining, how the reseller is determining how their products are sold via the platform.
And so indeed, I think what your question addresses is the situation where the definition is fulfilled, so the platform is a mere service input provider. And that is a situation where then the buyer of these input services can impose restrictions on the supplier of these input services. And yes, that follows logically from the classification as a supplier. Now, you've also mentioned agency agreements. This is also something that I would think is very common in the platform industry, platform economy, that platforms structure their business models around these agency agreements. And I have only two remarks on this. One is and I think Ricardo mentioned it at the beginning, it's not about form, it's about substance. So from a competition angle, you have to assess whether under competition law, this is really an agency agreement and whether it's a genuine or non-genuine agency agreement. You cannot get away with just calling an agreement a genuine agency agreement. And also the notion of agency agreements might be different in contract or commercial law. So that's one thing to keep in mind. It's just like what some people call a platform might not be a platform that meets the definition of online intermediation services. So I would really caution to say this is an agency agreement, this is a platform. You still have to apply the rules and take into account the guidelines. And there's one paragraph also in the new vertical guidelines that deals with agency in the platform economy. And there are good elements, good reasons spelled out in that paragraph that argue against qualifying vertical agreements by platforms as genuine agency agreements.
So just to complete the EU picture before we turn to the UK, then there are also hybrid platforms. Those are the platforms that not only provide online intermediary services, but who also compete with the reseller on the downstream resale market, for instance. So again, we have a horizontal relationship there, which of course needs to be looked at. And the Commission decided to look at it by carving it out of the exemption. I simplify this maybe, carving it out of the block exemption. But again, we have guidance in the guidelines, which helps with the individual assessment. And just because we want also to cover the other topics, but just a brief word on this again. Here, I assume that the assessment is really to look at every single agreement and the relationship, and there whether this competition relationship exists between the reseller and the platform or not. And if there's no competing relationship, then actually we are still in block exemption territory.
Yeah, and I'm actually grateful that you give me the chance to comment on this, because this is also something that has changed since the publication of the draft new VBER and draft new guidelines last year. I think the guidelines make now really clear where the issue lies and give some comfort, not only comfort at the end of that section saying that when it's a smaller, I'm also simplifying, when it's a smaller platform, hybrid platform, there's normally no reason for the Commission to intervene. But there are also two clarifications that clarify the scope of this exception to the dual distribution situation. And one relates to the fact that the competition has to take place within the same relevant market when it comes to the goods or services that are sold downstream, not only by those using the platform, but also by the platform itself. And again, we've mentioned it earlier, there are situations where a platform acts as normal reseller, and that is a normal distribution agreement that is not affected by this hybridity of the platform, and that is also covered by the vertical block exemption regulation. So I think this should really give some comfort to hybrid platforms. And also what I've heard a lot is there's this that this is a hybrid platform carve out, and I think one has to be very careful with this because it's a carve out for specific vertical agreements of hybrid platforms. So it's again very vertical agreement specific, and I think if you consider all of this, the exception to this dual distribution exemption is maybe not as cumbersome as one might perceive.
And looking at the UK, so there's no such carve out, which we just learned isn't in the EU neither, but in the UK, also from a technical legal perspective, there's a lot spelled out that hybrid platforms couldn't benefit from the block exemption. At the same time, obviously, you're very aware of the horizontal element here, and I'm sure you will take this into account in the assessment. If I may ask you for a brief comment on that before we go to the next topic.
Thank you. Just going back to the original point of online intermediation services, I think it's important to mention that the UK position is similar to the position adopted at EU level in that in our block exemption order, we make clear that where providers of online intermediation services, they meet the conditions set out in the definition, that they are to be treated as suppliers. And that obviously only applies where those platforms are acting in their OIS capacity. There will obviously be a range of other vertical agreements in which they enter into outside of that capacity, there in which a self-assessment will have to be carried out in order to establish whether they are the supplier or the buyer. But it is clear to us that where they are acting in OIS capacity, that they should be treated as suppliers. Then the other point about agency, which we clarify in the draft guidance, is that in principle, a provider of OIS services is unlikely to meet the conditions for a genuine agency. And I think it's important to note that we use the wording in principle for a reason. It was not the intention to say that it will never be the case that it will meet the conditions for genuine agency. We just say that it's unlikely, given the way in which the definition is set out, and we explain why that is the case. We set out in some detail that providers of these types of services, they typically act independently from the undertakings and sellers to which they provide those services. They also act for a large number of sellers. They make significant investments. So in other words, they do bear significant commercial and financial risk, and that's a key consideration. But we are aware, well, in particular during the course of our consultation, representations were made to us about the need to clarify that this is the case, and this is a point which we are carefully considering as we prepare the final version of the guidance. And then there's obviously the issue of hybrid platforms, where we think we have taken a different view from the Commission, and I think we set out publicly already some of the reasoning behind that.
But so would you say that the scrutiny in the UK with regards to hybrid platforms is less strict than in the EU?
Well, I think we share in terms of the UK versus EU position, we share concerns, competition concerns that may stem from vertical agreements entered into by hybrid platforms. But it is true, and we explained that in the recommendation to the Secretary of State, which we made in October last year, that we don't see, at least at this stage, sufficient evidence for us to treat hybrid platforms differently to other types of platforms. We just don't see the theory of harm or specific evidence at this stage. But having said that, we did, and this brings us closer to the Commission's position. We did mention that if competition concerns were to arise in relating to hybrid platforms, we obviously reserve the right to carefully consider withdrawing the benefit of the block exemption. And this is actually a matter which we will keep under review until the next review point. As you well know, the duration of the UK block exemption order is slightly shorter. Well, it's significantly shorter than the EU one. Because it will only be in place for a period of 6 years. And we did signal in our recommendation to the Secretary of State that we would keep this particular issue under review, and I think that's testament to the fact that we do understand that there are some potential concerns around that area.
So an area where for the time being there's maybe more flexibility in the UK, but we will see when the next consultation comes whether it stays this way. So going to the next topic, which is selective distribution, in particular online restrictions. So we stay in the online environment. Regarding selective distribution, I may just briefly summarize. I'd say the selective distribution is being even more protected by the new rules. It sets us very clearly. Selective distribution is available for any kind of products. Criteria can be qualitative as before. Criteria don't need to be published. And the combination of exclusive and selective is much better possible now. I think the most interesting part here really is looking at qualitative criteria in the online environment, and why it's not directly related only to a selective distribution system, but maybe it's more often implemented in a selective distribution environment. So the quality criteria often lead to online restrictions in the online environment, but they also bring, of course, efficiency. Therefore, not all online restrictions are illegal. Now, under the new VBAR, we have a new hardcore restriction with regards to online restrictions, which brings, of course, clarity regarding the scope of which online restrictions could be forbidden and a hardcore restriction, but also, again, leave maybe room for interpretation. What is now a hardcore restriction and what is a permissible restriction? Do you want to comment on that, Johannes, and where to find the right line between hardcore restriction and permissible restriction?
Sure. Maybe let's start with the fact that the new hardcore restriction in the vertical block exemption regulation 4E really builds on the existing case law. So the Pierre Fabre judgment, Coty judgment, and this provides the framework, and this is now put in for Article 4E as a framework for assessing online sales restriction. And I think if you look at Article 4E, it has this reference to the restriction of territories and customer groups, and that really brings it in line, or has a reference, links it with the other existing hardcore restrictions. So again, this is not a revolution in my view, it's like an evolution. It builds upon case law, it uses the existing hardcores, and introduces this notion of preventing the effective use of the internet for the sale of the contract goods or services. And of course, there is a question of what is the effective use of the internet. I think it's important, one, that it's in the VBAR itself, so it gives us also the chance to ensure some harmonized application as to what that actually means. And there's also a recital again on this that explains it. I think you have to read Article 4E together with this recital. I think it's recital 15. And then, of course, the guidelines. The guidelines have now sections on marketplace bans and give really detailed guidance on this. And I think together it provides a good package for setting out a principle and some concrete guidance. And I think this sets the framework for it. I mean, of course, we will discuss what does that mean, effective use. And this is probably not the last panel that will discuss this, but it's a start. I think it's a good start.
I also think it's a good start from private practice perspective. I actually think it's more than just a good start. I think the guidance and the guidelines and the guidance provide really helpful indication on what is the prevention of the effective use and what is allowed. And we definitely welcome also the explanation on marketplace bans, qualitative criteria regarding advertising, and so on. I have one more specific question regarding the guidance, where it says sometimes in order to see whether the hardcore online restriction is actually fulfilled or not, one can take into account content and context of the restriction, but it cannot depend on market-specific circumstances. I'm really sorry to ask you this question, but I would like to know, what is the difference between content and context on the one side, which can be taken into account, while market-specific circumstances or individual characteristics shouldn't be taken into account?
So in my view, this is really not an effects analysis, and I think this would go run counter the concept of hardcore restrictions to conduct an in-depth analysis of the effects of a restriction. So that's maybe one first remark. And then the content that also allows us and stakeholders, companies, to take into account other restrictions. So the online restriction that you're looking at under the new hardcore restriction might be combined with other restrictions. And I think this is the hook to look at these online restrictions in combination with other online restrictions. So that's what it is. There again, there's more guidance also in the recital concerning the total online sales and the potential aim to reduce the total online sales. And this is meant to give more guidance, but it's meant to give more guidance on something that is not an effects analysis under the new hardcore.
So looking at the UK, so the UK did not opt for a new hardcore restriction. However, I would say the test of preventing the effective use of internet comes in disguise as part of the passive sales ban. Is this a fair summary?
I think that's right. In the UK, we didn't include a specific hardcore provision in the block exemption order, but there should be no doubt that these types of restrictions should be treated as hardcore restrictions. So the CMA draft guidance does clarify that these restrictions, which directly or indirectly prevent the use of the internet, should be treated as hardcore restrictions, because in essence what they do is that they restrict the territories into which and the customers to whom the distributors can sell. So in that sense, going back to Joanna's point, that this is not actually a revolution. This is something which was already part of the previous regime. So I think that this is an important point to make. And then to some extent, as you mentioned, online sales are still, let's say it's fair to say, to a large extent, they're still treated as passive sales, and so very limited restrictions can be imposed on active sales. Having said that, I do note that in our guidance and also in the block exemption order itself, we did update the notion of active sales, which now includes a number of typically online strategies. So it is no longer the case that all online sales are necessarily treated as passive. But I think it's fair to say that the majority will still fall under that category. So I think in practice that there aren't significant differences between the EU and the UK regime in this regard. And in addition to that, there is also in the UK domestic case law, and I'm referring to the Competition Appeal Tribunal judgment on Ping, which was upheld by the Court of Appeal, which established that outright online sales bans should be treated as object restrictions. So I think all of these together create sufficient legal certainty around what the position is around this area.
Thank you very much, and sorry for the outside noise. That was the revolution outside. So going to the next topic, which is exclusive distribution. So Warsha and I, we looked at exclusive distribution and the topics we wanted to discuss during the session, and we really thought what one can say is there's more protection now of exclusive distribution systems under the EU regime. One can have up to 5 exclusive distributors. In the UK regime, a limited number. But we really thought what is more interesting than this for the discussion today, given that we have both the EU and the UK sitting at one table, is to look at export bans between the UK and the EU. And with that, I hand over back to Warsha to conduct through the last bit of the session.
Thank you very much, Savanaz, and hopefully you can all hear me and there are no sirens in the background to distract anyone either. So as Savanaz mentioned, I think our audience, and certainly we, are very keen to know more on the current position regarding export bans for both UK and EU suppliers. And my first question was to Ricardo, to really referring back to the CMA recommendations to the Secretary of State that you referred to previously. If I'm reading that correctly, these acknowledge the importance of clarifying the legal position regarding territorial and customer restrictions between the UK and EU, given, of course, that businesses often operate between them. So no surprises. My question to you is, what is the latest position on this?
Thank you. This is a very hot topic, and it's probably the issue that gets raised more frequently by our stakeholders. We're acutely aware that this is a legal or a complex legal issue for businesses that operate cross-border, and I think it's also fair to recognize that it's no easier for the CMA to deal with. It is indeed a very complex issue. However, I would like to say a couple of things on this matter, bearing in mind that we did provide some thoughts on this issue in the draft CMA guidance, and that we're currently we're working very hard to provide further clarity following from the consultation. As we understand, this is an area where stakeholders have called on the CMA to be clear and firmer and provide firm guidance on this matter. So I would like to stress that none of this is the CMA position. This is my personal view on these issues, and I hope that's helpful. The first thing to bear in mind is that the Chapter 1 prohibition only applies to agreements that may affect trade and restrict competition within the United Kingdom. So this is really the key substantive legal test. There is, however, a preliminary issue, which is an important one, which is about jurisdiction, and that's from a UK domestic legislation perspective. It's dealt with in Section 2.3 of the UK Competition Act, which states that the Chapter 1 prohibition applies only if the agreement, decision, or practice is or is intended to be implemented in the United Kingdom. So in the draft guidelines, we clarify that, following from this statutory provision, it's clear that the block exemption does not apply to agreements implemented or intended to be implemented outside of the UK. And we did refer to the jurisdictional test in Section 2.3 of the CN98. So what does this mean in practice? It means that if an agreement contains a hardcore territorial or customer restriction and is entered into two or more undertakings, even if those undertakings are located outside of the UK, then the agreement may be found to infringe UK competition law, and subject to the substantive and jurisdictional tests, which are set in the Chapter 1 prohibition in Section 2.3 of the Act. Now, having said that, we note that the UK government has publicly committed to removing the implementation doctrine requirement from the Competition Act, and in its response to the consultation on reforming competition and consumer policy. So given this, we believe that at this stage it would be premature to issue guidance on this possible change, given that it's still very, very, very early days, and those changes do need to come to fruition before we can issue guidance. In relation to any possible restrictions of reselling outside the UK, we consider that this is a slightly different issue, and we think the current position on this should be clear to business from the subject matter jurisdiction of the Chapter 1 prohibition, and also should be clear from the CMA's focus on which is to protect UK consumers. So leaving aside all the legal issues, it should be clear that the CMA's prioritization criteria is clear in that we will only target anti-competitive conduct which harms in some shape or form British consumers. So if the harm is elsewhere, I think it's fair to say that we would be unlikely to prioritize taking action. Although it should be noted that consumer detriment is one of the main prioritization criteria for the CMA, but it is not the only one, and we do carry out prioritization assessments on a case-by-case basis. So I think this is what I wanted to say at this stage about that important issue. As I said, we're acutely aware that there's a call from a large, very significant number of UK stakeholders for greater clarity in this area, and we're working hard to provide that in the final version of the guidance.
And I think we very much appreciate your insights today, and thank you for sharing what you can at this stage. So my next question was for Johannes, and I suppose the background to this is quite often when businesses structure distribution agreements across the EU, they will include Switzerland within those because of the possibility, the strong possibility quite often of goods being re-imported back into the EU. And given that the UK is now not part of the EU, my question is the UK the new Switzerland in terms of having to be included in EU distribution arrangements?
So I think it's a very interesting question for me, and I understand that this is really a hot topic in the UK at the moment. I mean, from my perspective, this has already been dealt with under the old vertical guidelines. It's now made a bit more prominent because it was hidden in a footnote before. Now it's also in the text, but the reference remains the same, and that is the Jabico judgment of the Court of Justice. And I think that still says it all. You conduct an effects analysis, and the notion is, or the idea, the principle is the same. We're looking at distortion of competition within the EU, and if that ultimately leads to an effects analysis of the restrictions, and I think for me that's basically it. So I don't think, I mean, yes, it's another example of possible export bans that become more prevalent due to the new circumstances, but I think in the end, it's the same old principle that applies, and that has been part of the EU case law for quite some time now.
Thank you very much. I wish we had time to go into some of the vagaries of the Trade and Cooperation Agreement and to what extent that encourages rather than anything else to trade between the EU and UK. But I think we should move on to our final topic before we open it up more questions. And that was the treatment of wide MFN parity clauses, which I think it's fair to say it's a clear point of distinction between the EU and the UK legislation and guidance. And just to recap for those who are not familiar, in the UK, both online and offline, wide retail parity clauses, which is clauses where the manufacturer or the supplier agrees not to give better terms to any other sales channels, which could include its own sales channels. Those kinds of clauses are considered hardcore restrictions, whereas, if I'm reading it correctly, in the EU, across-platform retail parity clauses are excluded from the block exemption, but they're not considered hardcore. So, Ricardo, my question, my comment actually to begin with, the driver in the UK seems to be the CMA experience. I think there's references in the CMA recommendations to the investigations of private motor insurance and also the price comparison website infringement decision. But there's also references to efficiencies. I think the CMA really leaves the door open for efficiency justifications. And I was wondering, I would take on board fully what you said previously about businesses being in the best position to assess efficiencies in an individual case-by-case basis, but could you perhaps give us any broad brush examples of what kind of efficiencies might need to be demonstrated? And as far as I can see, just a very quick footnote, that there's only one in the recommendations, which is referring to a wide MFN benefiting a new entrant. Are there any others?
Thank you for that question. You are right that the private motor insurance investigation in 2015 was really one of the key pieces of CMA work, which highlighted the high propensity of wide parity obligations to distort competition, to restrict competition. And in addition to that work, we did have enforcement activity and an infringement decision in the price comparison website, noting that that case is currently under appeal at the Competition Appeal Tribunal. But over the years, the CMA has made several public statements expressing concerns about wide parity obligations, and there was a clear line drawn between wide parity obligations and narrow parity obligations. In relation to the latter, we recognize that there is greater potential for efficiencies than in relation to the former. And that's why we did not decide to elaborate or expand significantly on efficiencies, because we do believe that these clauses have a high propensity to prevent competition. But having said that, as a way to somehow soften the hardcore approach, we did want to send a strong signal that we would be carefully and objectively considering any possible efficiency justifications. And as you mentioned, one possible efficiency justification that it's raised frequently in the economic literature and by a number of stakeholders in their response to our consultation is the argument that in some cases wide parity obligations are necessary to ensure that there is viable entry. Well, I have to say personally that in many cases where that argument is raised, I could see plausible alternatives to ensure that those efficiencies could be delivered, and through least restrictive means of competition. So I've personally been skeptical of those justifications, just because I could see alternative means which were perhaps less restrictive, and for example, narrow parity obligations can also be used to some extent to ensure that those efficiencies are delivered. But at the same time, I wanted to make clear that the CMA position is that we acknowledge that there is potential for efficiencies, but the onus and the burden of proof in this regard will be on businesses. So we wanted to ensure that despite our approach to wide parity obligations, that we left the door open for businesses to raise credible arguments, and we will obviously carefully consider them when the moment comes, in particular in the context of competition investigations.
Thank you. That's very interesting. And then I suppose the question for Johannes, following on from that, is given what Ricardo has just said in terms of that there is the door open still for efficiencies, even though at this stage we might not be able to quite quantify what those would be. Would you feel that in practice there's perhaps less of a difference between the EU and the UK enforcement approaches, given also that the UK approach stems from the investigations into PMI and of course price comparison website online investigations, or would you see them as more divergent at this point?
I mean, when it comes to enforcement experience, I think this is also the major driver behind this excluded restriction, or this new excluded restriction relating to across-platform parity agreements. And the question is only, I mean, in the end, it's also, what does it mean to be included in the excluded restrictions list of the WIBOR? It means that you have to conduct an individual assessment of the particular restriction, meaning the across-platform parity agreement. But then the question is, do you go one step further and say it's a hardcore restriction? That would also mean that the remainder of the agreement would be void. So I think that's maybe the technical difference. In practice, I personally think that it can have the same chilling effect on companies using across-platform parity agreements. So in the end, when it comes to the use of that clause, maybe the result is similar. Whether you put it in the Article 5 or Article 4 box may lead to the same result in relation to the use of that particular restriction.
Thank you. And so perhaps a less of a divergent question, but to both of you. So when we're looking at narrow parity obligations, would we consider the EU and the CMA basically aligned in their treatment of those, in terms of there's always the possibility of potentially withdrawing the benefit of the block exemption if necessary, but ultimately the sort of general analysis would be more similar. Ricardo, sorry, I should have pointed at you.
Let's keep the good order.
Well, I can only speak on behalf of the CMA, but having read with interest the Commission's final guidance, it does feel like there's to a large extent the positions are aligned, in that we did send a strong signal in the draft guidance that we would, despite our confidence that narrow parity obligations have a higher propensity to generate efficiencies, and that's why we decided that they should be block exempt, subject to the general conditions of the block exemption being met. We do have some concerns that in certain cases, the widespread use of narrow parity obligations can actually replicate the effects of wide parity obligations. And we wanted to send a signal that if competition concerns were to arise as a result of the use of these narrow parity obligations, we would give consideration to the mechanism of withdrawal of the benefit of the block exemption. But I think this was more around signaling than anything else, because obviously the mechanism of withdrawing the benefit of the block exemption applies more broadly, not just to narrow parity obligations, but to any vertical restraints that meet the conditions of the block exemption.
Thank you.
Yeah, and if I may add, so I think the evidence gathered during the review of the old vertical block exemption regulation, where all types of parity obligations were block exempted, I think it didn't justify adding also narrow parity to the list of excluded restrictions. And that being said, there's this very similar argument that by putting a clear message in there, and now it's actually in the Weber, in the final text, that a withdrawal is possible in relation to narrow parity obligations in certain circumstances, namely when the market is really concentrated. And there's more guidance on this in the guidelines, that this will justify or would justify a withdrawal by the Commission, and then allowing the Commission to take also action when it comes to narrow parity. I think that's very clear. And I also wanted to just mention that there's a whole new section on parity obligations in the vertical guidelines, also with the theories of harm, efficiencies, and there are even examples there also relating to narrow parity. I think this is now very much covered by the guidelines, and that's a very good starting point for the future, allowing companies to self-assess their parity obligations, and also providing a framework for competition authorities to look into parity obligations.
Thank you very much. And that goes back to my first point in terms of how invaluable those guidelines are for companies looking to self-assess. I think the formal part of our webinar is over, so we're going to open it up to questions. And if I may, I will continue to speak at you from afar. So the first question that we have from our audience is, why are online sales considered passive when platforms use search engine optimization to attract buyers to their platform? Ricardo?
So I think I briefly touched upon that. I think it's fair to say that typically they will be passive, but the new regime does make clear that where online sales are being used to target particular groups of customers, that they fall into the active sales category. So I think that's an evolution from the previous regime, and it's now explicitly acknowledged that not all online sales strategies necessarily should be categorized as passive.
Thank you. Johannes, do you have anything to add to that?
Well, I think for me, the question about active and passive is maybe not so relevant anymore when it comes to online sales restrictions, because we have a new hardcore in the vertical block exemption regulation. But there's also guidance on search engine optimization in the guidelines, brand bidding restrictions, etc. And here, I think coming back to the main principles, it's really this idea of being allowed to advertise online. It's to be found online, you have to advertise. And the notion, and coming back to the old case law, Pierre Fabre, Coty, I think very much, my view very much rested on this idea of you should be able to set up a website, web shop, advertise online and attract customers. And if you can do that, then maybe even a platform marketplace ban is covered by the vertical block exemption regulation. And I think this idea of being able to advertise and sell online, I think is very much embraced in the new Weber and the vertical guidelines. And it's went away a little bit from this active and passive sales distinction in the drafts that were subject to public consultation. Last year, there was also this whole online sales restrictions discussion was embedded also in the passive sales definition. And that again goes back to the old guidelines, which qualified all online sales as passive sales. So it's basically a bit of the historical background to the new hardcore restriction, which will guide the assessment of online sales and online advertising restrictions.
Yeah, no, absolutely. That was a technical and complex question. Now I'm going to ask potentially a very simple question, and this is specifically for Ricardo from the audience, which is, when will the CMA issue the finalized guidance to the Purveyor?
Thank you. So we recently provided more information on our website, on our webpage about the publication, acknowledging that the UK block exemption order has come into force on the 1st of June. So we're working really hard to get the accompanying guidance published as soon as possible, really. So it will be published in due course.
Can't give us any more than that. Not yet. Not even in a personal capacity.
I cannot commit to a specific deadline, but I can say that it will take place in the short run. We're not talking about months; we're talking about probably weeks.
So Johannes, compared to the UK, it's not so bad. In the EU, we are only waiting for the language versions.
They will follow in due course.
In due course. Okay, so thank you very much, Ricardo. I appreciate that there are many wheels which are turning at the moment within the CMA. So I have a question for Johannes, which is again specifically for Johannes. How are we going to avoid member state agencies and member state courts from deviating from the approaches set out in the guidance? And I think specifically one point which might be interesting is the fact that we have this new hardcore clause in the block exemption. I think that might be something which might help, but over to you.
So first of all, I agree. If something is in the Weber, of course, it's binding for national courts and national competition authorities. The guidelines, it has stakeholders mentioned that the guidelines, or they highlight correctly that legally speaking, the guidelines are not binding, but obviously, and this is something that the evaluation has shown in the evaluation support study, I think you can see this very nicely, that they also take into account the vertical guidelines. So whenever there is a dispute, they also make reference to the vertical guidelines. And there are existing mechanisms. I mean, before joining this unit that dealt with the Weber directly, I was also in the ECN unit, and there are constant discussions between national competition authorities about cases, including vertical cases. There are good mechanisms to have a good overview and ensure consistency. And the rules and regulation one also help. So I think the rules are in place to ensure a harmonized approach across the EU, and whatever is in the Weber obviously helps to shape harmonization in the EU.
Thank you very much. We have about 5 minutes left. I was wondering, if I may, slightly cheeky questions to both. So to Ricardo and then Johannes, because that's the order we seem to have adopted. What were your three biggest learnings in the process of the revisions?
Well, I think one of the main learnings, it came as a bit of a surprise, was the high level of engagement of UK stakeholders in this space, which was well, that the level of engagement was somewhat unexpected in that it was particularly high, and it was a pleasant surprise, and which gives us also the confidence that going forward we'll be able to be assisted by stakeholder feedback as we progress into the next review stages. So that was one of the learnings, and which is one that gives us a lot of confidence for the future. In terms of, we obviously already alluded to the fact that the vertical guidelines were in place in the UK for quite some time. So one of the challenges for us was really to try to strike a balance between legal certainty and consistency, while on the other hand trying to reflect some elements and introduce some changes to the current regime to try to reflect the specifics of UK markets. I was also struck by, as I was going through the evidence and all the information that we gathered, by the pace at which markets are evolving nowadays, and notably digital markets, which is obviously a challenge for authorities then to keep ahead of the curve. And that was one of the learning points for us, and one that probably led to the conclusion that in the UK case, it would be preferable to have a shorter duration, so that it would give us or force a review point earlier than it would otherwise be the case, to enable us to react to any ongoing market developments. And then I think. Well, I think this is really it in terms of learning points. It was obviously pretty challenging to carry out a review, which was initially led by the Commission for quite some time, and then we had to carry out a review based on UK stakeholders and UK markets over a fairly compressed timetable, which was pretty challenging, and as I said, we're pretty happy with the final results, and we're obviously still working to get the guidance out, which will then mark the end of the process.
Absolutely. Thank you very much for that. Very insightful. And same question to Johannes. You had a little bit more time to think about it.
No, that's true. So the three biggest learnings, I think, I have three, and they all interrelate. So the first one is, it's important to engage with stakeholders, and their feedback is very important. And because you can really see some things you got right or some things you got wrong, and the feedback from the stakeholders is very important. And I think it's important to make this process as transparent as possible, and that includes going to conferences and speaking about it and engaging in webinars like this. So I think this is very important. Stakeholder feedback is very important. And the second point is, I have two temptations. The first one is to get lost in the verticals world, because antitrust is already very technical and something for experts, and then verticals is even more technical and even more something for experts, it seems. And so the more you deep dive into this, the more of an expert you get, and you sometimes get lost in these technicalities. And I think it's important to take a step back and again engage with stakeholders. That's very important and helpful to have a fresh look at verticals and look at it also from a more high level perspective. And the third one is another temptation, which is to go into into much detail in the guidelines and also in the regulations. So I think thinking also about the duration of these new rules and the guidance, it's very important to have good principles that can be applied also in 6 years, 7 years, 8 years time. It needs to be combined with good practical examples, but you can also not overload the vertical guidelines. If we put more paragraphs in there that deal really with all the details of a firewall, etc., I think this is micromanaging, which is not really helpful for stakeholders. And what's good is this combination of principles in the regulation and examples, practical examples in the guidelines. And again, this is with the experience, the evidence gathered through a review that has lasted almost 4 years. I think there's a very good evidence base for the new rules, and they will make sure that they can also be applied in 6, 7, 8, 11, 12 years.
I was wondering whether you were going to say 12. Thank you so much. That's really it from me. Thank you, from a personal level. Again, very sorry I couldn't be there, but you've done an amazing job, all of you, in illuminating some of the real complexities associated with the vertical legal framework. I'm now going to hand back to Margarita, who's going to formally close for us.
Thank you very much to Johannes and Ricardo for all the insights, and for Sarvenas and Warsha for the carefully thought moderation through the complex topics. A recording will be made available should you wish to watch the webinar back. We look forward to welcoming you next time. Thank you everyone for joining. Goodbye.